Hello and welcome to another very exciting episode of your #1 legal talk show, The Courthouse. Yes, it's a talk show and we always have legal experts for you, sharing their knowledge, sharing their expertise with you on matters relating to the law. I am Ito and Olomu-Agbodo, but first we'll go on a quick break. We'll be right back. Stay with us.
If we have to give you anything, then we have to give you everything. Love Plus Channel 465 is simply the best. Because we have something for every member of the family. So dads, keep the team spirit going on with our intriguing sport highlights and reviews. And moms, cooking is never boring when you have our intriguing drama series. And for all your lovely kids, just sit and enjoy. This, and oh this. I told you, we have something for everyone. Because we are indeed all about you. So keep it locked on Love Plus Channel 465 on Star Times.
You're welcome back. If you just joined us, this is the Courthouse and I'm Ito Olomu-Agbodo. And this week on the show, we are taking a look at something very, very interesting. I did tell you at the beginning of the season that we'll be taking a look at some controversial and not so controversial issues of the law, but they are all going to be related to the law and they are all going to benefit you. So this week, we are taking a look at contempt of the court, or simply put, violation of court orders. Violation of court orders is something that we've been hearing in the news, and I have someone very interesting. This is first time on the Courthouse, and he is Agbaka. He is the principal partner of Agbaka Chambers, and he is a human rights crusader. Crusader because he mentioned it that way as a human rights crusader. So you're welcome to the Courthouse.
Thank you very much. I'm very happy to be here.
Okay, I'm happy to also have you here at the Courthouse to crusade for human rights. Okay, violation of court orders.
Not just crusade, an unrepentant one.
Oh, unrepentant crusader.
Yes, thank you very much.
Okay.
Yes. This issue of disobeying court order has become our norms since 2015. After the man who wore khaki decided to transit with Agbada. The what speaks behind the Agbada is the khaki, because the man is used to the khaki life. I don't want to personalize it, but the facts are there within the public domain.
Okay.
This is a government who chooses the law and the order of the court to obey, and chooses whose order to be obeyed. Let me adumbrate a little.
Okay.
Now, when the court granted order that the former CJN, Onoge, should be removed, that order was obeyed almost immediately. In fact, before the order was given, steps has been taken to give effect to it. And then an order was given again before a court of competent jurisdiction granting bail to Dasuki. That order was swept under the carpet. And it continued to stink that even those who refuse to obey it are beginning to cover their nose and nostrils. And this disobedience of court order is a call for anarchy. Because if you look at the Constitution, precisely Section 4 set as the legislature. Their powers are defined. And it says the legislative powers. That is the heading. Section 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. It said the executive powers.
Yeah.
Then Section 6, which created the judicature, say judicial powers. These three entities are not supposed to be coterminous in carrying out their functions, because each is supposed to have an oversight function or a supervisory function over the other. But unfortunately, what is rolling up and rolling out in Nigeria is an intimidation and frustration of the judiciary. Because where an order of court is not obeyed, the whole essence of approaching the judiciary becomes an effort in futility. It becomes a baseless attempt. How do you enforce a court order? Becomes another question that is begging for an answer. You now need the executives, that is to say the police, the DSS, and whatever. These people have been tied to the apron stinch of the
executive.
The head of the executive, not just the executive. Somebody sits in Aso Rock and says, this order must be obeyed, this order must not be obeyed. That is the situations Nigeria has found themselves. And then, I have just said that we choose the order to obey. But even choosing those orders to obey, you'll find out that those were the orders we want to obey because we approached the court to get those orders. I can give you instances of cases that even I and some of my colleagues were involved. I have a case against the Nigerian police for the unlawful sadistical murder of one Edewo. Oyoma Edewo was being towed by a towing van whilst he was in his broken vehicle. The police flagged him down. The towing van did not stop immediately, and when he stopped, he left. They came, dragged the gentleman out, a civil engineer, by calling, and shot him to death. We approached the court, presided over by Honorable Justice Hassan of the Federal High Court. We got a judgment in the neighborhood of 50 million. As I speak with you, nobody has obeyed the judgment. Even when we commence a contempt proceedings, because the judiciary has been so intimidated, they will not rise up to the occasion to say,
so
let me commit.
I was going to ask you that then what is done when the orders of courts are not obeyed? What should be done? How can you, who else do you approach?
There are various ways to enforce a judgment of a court. If it's monetary, you can go by garnishing the account of the judgment debtor. But one serious question is that where you have filed a garnishing proceedings against any of the agencies of the Federal Republic of Nigeria,
how do you go?
the Attorney General will come up and said, you needed my fiat for you to enforce it. But that is an obnoxious law. That law has no place in our legal system. It has no place at all. Because, for instance, where the Attorney General of the Federation is joined as a party, and possible, like in the instant case I've just cited, there is a substituting order that the Attorney General of the Federal Republic of Nigeria should ensure that the judgment of the court should be obeyed. Now, as we speak, it's in contempt. And when you want to garnish the police account, they now come up and say, he's a public officer. You are supposed to obtain the fiat. Fiat is a mere leave, a mere permission. And the whole essence of that fiat is to put the Federal Republic of Nigeria and or his agency on notice so that they will not be caught napping. But where you have joined them as a party and they were in court, they filed all processes, they were in court when judgment is given, and notwithstanding that, you wrote them to inform them. The whole essence of fiat becomes a rigmarole because it has no place. Even there are authorities that have said that you don't need fiat. It's a common law principle. It's not provided under our law. And if you look at the Constitution, it says all persons and authority must obey the judgment of the court. There is no exception.
There's no exception to the law. No.
But we have come to a situation where, because of this issue of randomizing the order to obey, we'll now say, no, let's look at it this way, let's do it this way. We have gone back to the dark ages where the core brute of force, the military jackboot, was marching forward and directing the destiny of Nigerians. I have always said that it is wrong to say that Nigeria is on the reverse when you put the gamut of all evidence together. If we're on the reverse, it would have been better because we would have gone back to see where 20 naira will be able to buy $1. If we're on the reverse, we would have been able to see a situation where you can buy a Peugeot that is assembled in Nigeria. If on the reverse, we have been able to see a situation where you frown on a lady jumping on what we popularly call Okada. Because in the 70s and 80s, those were not the phenomenon. People drive cars. So we're not on the reverse. We are static. We are ignoring. We're in the darkness. We're glooming the darkness.
And it's worse than
so,
being on
and
the
the
reverse.
painful thing is that I know some non-governmental organizations has gone to court and said, court granted an order. Can we know our local and foreign debt profile? Set up, to be precise. That order has not been obeyed today. And you can see what is happening too. A situation where public officers will refuse to declare their assets openly. And then when we want to witch hunt some of them, we'll go back and say, we'll confront you with this evidence. But the same we have waived it at that stage and said, no, there's no problem, you can go on. The hide and seek game that is playing out in Aso Rock, to be precise, because the head of the executive is in Aso Rock, was not what was expected by Nigerians in 2015. This disobedience and consistent and persistent disobedience of court orders leaves much to be desired. It is a shame. It is a drawback to a moving train.
Okay. It's a shame and it's a drawback to a moving train. We are supposed to be making progress as a society and as a democratic nation. Nigeria should be seen as a nation that obeys court orders. And that is why our guest this week, Agbaka, has been very, very passionate about this discussion, talking about violation of court orders, choosing which court orders to obey or not to obey. But we have a report for you on this topic and our legal nuggets. Stay with us. Violating a court order. Courts issue orders compelling people to do certain things for a wide variety of purposes. Violating a court order is subject to penalty. Most of the time, court orders spell out the cost of disobeying such orders the moment the order is issued. The precise penalties that are attached to any violation of court orders are usually a matter of judicial discretion and are always set out and authorized by the local law. Violating a court order in one place may yield a different penalty than a similar violation would elsewhere, though more depends on local law and the facts at play. The cost of violating a court order is often calculated based on the nature and significance of the facts that gave rise to the order in the first place. A court order for one party to appear is usually less serious than a court order requiring a person to keep a certain distance from another person or cease contact with another person, for instance. Most of the time, penalties follow a similar pattern. Welcome back. If you just joined us, this is the courthouse, and we've been talking about violation of court orders. Court orders are meant to be obeyed. When the court reaches a judgment or gives an order, the police, as an arm of the executive, is supposed to carry out the enforcement of those judgments. We did enforcement of judgments some time ago, but Agbaka is quite passionate about the fact that a lot of these judgments, sometimes political judgments, are not being obeyed, and that we are moving backwards, not even moving backwards, we are static. In your words, you said static.
Yes, we are static and stagnant.
And stagnant.
Yes.
But in other parts of the world, do we see these gross violations of court orders, court judgments?
No, you see, I may not be very, very specific, but I've been following the trend of things that happen in Ghana and even in South Africa. And you find out that once an order is given against the government, those orders are promptly obeyed. I didn't want to start looking at the civilized country, what we call today the Western world. But I and you know that in the Western world, the American, the Britain, once an order is given and a particular person is named, that order must be obeyed. But the unfortunate thing is we are in a situation where we even give an excuse that we are studying the judgment. And then we are in an era where somebody, a supposed lawyer, a gentleman lawyer, a purported lawyer of the highest level, said that because he intends to appeal, not that he has lodged an appeal, that he cannot obey the judgment of a court of law.
So what's the position of the law?
The position of the law is that at that point, which I know my learned senior would have started taking steps, is to bring a contempt proceedings by filing Form 48 and thereafter Form 49 for him to show cause why he should not be committed to prison for having disobeyed the court order. But just like I said earlier, who is the person to carry effect the judgment, even if the contempt proceeding is granted?
It's granted, okay. So
it becomes the same group of people.
The same group of people.
And these are people who have mortgaged their conscience. These are people who look at the masses of the people as conquered territory.
Okay, looking at this, people that should be enforcing the court judgments, but in looking at the judgments, if the judgments are against the government, and the judiciary is an arm of government, the executive, the legislature, they are arms of government, but this judgment now is against another arm of government, probably the executive, which basically holds the power over, seemingly over all these other arms of government. How can the judiciary ensure that these judgments are enforced, or is all hope totally lost when it comes to judgments against the government agency or a ministry, department of government?
Yes, at the stage we are now, the hope is in abeyance, about to be collapsed. Reason being that I have just cited instances where we have subsisting judgments of the Court of Competent Jurisdiction, even Court of Appeal, that has not been obeyed. And the judiciary, with profound respect, have been so intimidated to the extent that they have been castrated, that they have no venom to even vet their anger. Some of the judicial officers may be having corrupt, but not the totality of them. But what the executive is trying to do is to sample out those they will use to tarnish the genuine ones. So, and what they do too is they manipulate the system such that such cases go to those ones whom they could confront with one evidence or the other and say, if you do this, we are DSS, we'll have this dossier against you. But if we try as much as we can, as judicial officers, to live above the board, we'll be able to stand the test of time. Honorable Justice Jinadu, during the dark ages of Abacha, resigned his appointment because his order was not obeyed. Are we seeing such judges?
Okay, I was going to ask you what a judge like that can do. So that's a very good example.
Honorable Justice Jinadu, yes, of the Federal High Court, yes.
Of the Federal High Court, is stepped down. So are we saying all the judges now should step down if their orders are not being obeyed by the federal government?
There are some, like I said earlier, so that we don't miss the train, that they select the orders to obey. The ones they obey cannot resign. The ones that they disobey their order,
like the option case you mentioned.
Yes, the option will not be to resign for now, but the option should be for MBA to live up to expectation.
Okay.
And because the judges can be heard, but they cannot be seen. And because of the sacred nature of that calling, a judge, even where they're being slapped, they try as much as they can to muster, nurture, and feel the feelings alone. Their mouthpiece is supposed to be the NBA. But we too can see that some high-level players in the NBA too have been confronted with one allegation or the other. So whether it is true or not, Once an allegation has been made against you, you'll be weakened. That spirit to fight will be weakened. It is not all the people that heard about the allegation that will even hear when you are being exonerated. Because what we do today is media trial. We convict you before your arraignment. It's unheard. It's a new system. And I call on every Nigerian to rise up and say, no, this nonsense must stop.
I was going to say, are we going to start our own revolution in terms of the NBA and the judiciary asking for a revolution?
Yes, that the word revolution in recent time has been given a parochial definition. Revolution in the legal parlance. It's a mere change of the legal order. And the change of the legal order could be negotiable, it could be peaceful, it could be violent. The gentleman who talked about revolution did not qualify it with violence. Somebody decided to give it that coloration. And that's why I said that save and accept, we begin to reason as human beings that have purpose to serve a public office. We will not move forward because the whole essence of being an elected officer is to serve your people. It's not to go and start money and then frustrate a system that is supposed to be a watchdog. It used to be the words that the judiciary is the common place of the poor man. But most poor men does not have access again to the judiciary. You know how much it costs to file a case in Lagos State as a test case? A gentleman in Lagos State filed an action considering whether or not to review the filing fees and the penalties and others. The case was struck out and he was slammed 5 million or so. And with a mandatory time, within which to pay. So public interest cases are being discouraged. And we know when this started, from 2015. So even where you want to go to court and say, let's look at this and look at this, the man that is going to preside over the issues you are bringing has been so intimidated. He has been so cowed that the independence of the judiciary is now being questionable.
Interesting.
So save and accept, there is a complete departure from what is happening now, so that we will have a corrupt, free, and independent judiciary. If we continue to go the way we are going, it is a call for anarchy. Because where you know that if you go to court, you get a judgment, and the judgment will not be obeyed, then you begin to adopt to extrajudicial method to see that you get your grievance addressed.
Self-help.
So, I think if you look at some cases, let's say Savalak and Vaswani brothers, the Supreme Court had the occasion to lambast the federal government that once a case is before a court of competent jurisdiction and parties have submitted themselves to the jurisdiction, no party should take any step to overreach the pendency of that suit. We are not even talking about judgment. We are talking about a case that is sub judice. The same case, too, happened in Ojukwu and Military Administration of Lagos State, wherein the case was in the court, and that the military administration, as it were, decided to take steps to overreach the decision of the court. The same thing happened to Bello and Ejo State. While the appeal was pending at the Supreme Court, the man was taken to the poll because they were convinced, in their own mind, that he's a notorious criminal, and they executed him. So that is the situation we have come back to face.
Quite.
If somebody was granted bail on critical medical health, on grounds, sole grounds, medical health, and we said no, we're not going to allow him, we'll choose the order. And if we must obey the order, we'll vary it to suit our own condition. That is not the law. If you want to vary the terms of bail, you approach the same court. The court has given the terms, and that term stands. Save and accept it is varied or appealed against.
Thank you so much, sir. So, I can see you're indeed a crusader, and we don't want to use the word revolution for reasons of public interest.
No, I've explained
need,
it to, sorry, my
yes,
sister,
but we need,
so that the whole world will understand
we
that
need a paradigm
when you
shift.
use the word revolution, it does not connote and denote violent revolution. It could, to change a system is the revolutionary aspect of it.
Paradigm shifts and
Yes.
things like that.
But unfortunately, and very, very unfortunately, we are giving it a different correlation, because when you want to get a bingo, you must give a bingo that name.
Quite interesting. That's,
Thank you very much.
Thank you so much, Agbaka, legal practitioner based in Nigeria, talking passionately about the reason why court orders should be obeyed and calling on the Nigerian Bar Association and the judiciary to stand up and ensure that these orders are obeyed, to speak out against orders that are being violated, because it's actually contempt. Not to comply with the court order is a contempt of court. I have another segment. I didn't tell you about it because I actually wanted to see how you react. It's called the Bar Book, and we share Latin maxims. And any equitable maxim you remember, just tell us your favorite Latin maxim and the meaning. It's called the Bar Book segment.
Okay, oh, that's fantastic.
I know as a crusader, you may not be into so much Latins, or you may have to be
Tres magit varet quam paret.
Very good.
You interpret the law to suit the intention of the lawmakers.
Okay.
So that the intention of the lawmaker will flourish and not be defeated.
And not be defeated.
Yes. Or tres magit varet quam paret.
Okay. So, I'm not going to repeat that. He has already told us you interpret the law so that the purpose of the law will not be defeated. It will be achieved. Yes. You get to find out more Latin maxims on our Bar Book segment. Stay tuned. You're welcome back, but it's time we actually draw the curtain because we've spent too much time talking about violation of court orders with Agbaka. And at this time, I must say a very big thank you for making our time to be with us on the show.
My pleasure once again to be here. Okay. And I will always be here whenever I'm invited.
Thank you so much for that promise, and we'll see that you keep to that promise. Well, we'd like to hear from you. You can log on to our website on www.loveoplus.tv. You can send comments to us. The numbers will be shown on your screen now, and to our email, info@loveoplus.org. I am Olomu-Agbodo, and I say don't just get mad, go get a lawyer. Bye for now.